welcome to Criminalist Behavior Podcast, the podcast that takes you deep into the heart of Louisiana's history and current, most chilling true crime stories. I'll be guiding you through the darkness of these crimes and all of those involved. Each week, we dig deep on those forgotten crimes or those crimes currently happening with the underlying legends that continue to haunt us. So lean in, listen, and get ready because true crime is anything but ordinary. Stay with me as we unravel what happens in these mysteries. So today we're going to be talking about the case of Kathleen Mouton, also known as the Main Street grocery shooting, and this is episode number 39. If this is your first time listening, hi, my name is Sarah Soudier, and I'm your host for Criminalist Behavior Podcast. I want to thank you for listening to the show, and I really hope you enjoy it. So, trigger warning, this episode may contain content of a graphic nature, including descriptions of physical and sexual violence against adults, children, and animals. Listener discretion is advised. So, this episode isn't going to be too long. I just want to let y'all know off the bat. I am still having issues with my throat, as you could hear. But it's getting better little by little, so y'all just bear with me, okay? So, on July 31st, 2024, around 2:30 p.m., an altercation between two men took place at Main Street Grocery and Liquor, located at the 700 block of South Main Street in Jennings, Louisiana. Those two men were James Mouton and DeMarcus Charles. James and DeMarcus' altercation led to a shooting where one victim was shot multiple times. Officers responded to the scene where they located the victim, DeMarcus Charles, who sustained multiple gunshot wounds during this altercation. He was transported to the Jennings airport and then airlifted to Lafayette Hospital. Police say that the initial altercation between the two subjects, that one of the men actually left the scene and returned with his mother, who police identified as Kathleen Mouton. Kathleen Mouton is the one who showed up and produced a gun and allegedly shot the victim, DeMarcus Charles, multiple times before she fled the scene. Kathleen Mouton fired numerous shots, striking DeMarcus Charles in the torso and the leg. Kathleen Mouton was 42 years old at the time of this incident, and she was from Jennings, Louisiana, and she fled the scene after shooting DeMarcus Charles. Officers that were investigating this scene uncovered evidence that led them to a residence on South Street in the city where Kathleen Mouton was believed to be. At that same time, another call came into the dispatch with information that Kathleen Mouton was actually seen at another location, and that location is where police was actually to locate Kathleen, and she actually turned herself into police. So Kathleen Mouton was arrested and booked on charges of second-degree murder. She was transported to Jefferson Davis Parish Detention Center. And upon further investigation, she actually went in with the police without incident. She didn't raise no hell, none of that. So Kathleen Mouton was questioned about the shooting and the altercation that occurred, and she actually admitted to shooting DeMarcus Charles several times after her son and him got into that physical altercation. She was booked into the parish jail on the second-degree attempted murder, and she was held on a $200,000 bond. Now, I do know that at first it said that it charged her for second-degree murder, but then some stories said that it actually was a second-degree attempted murder. And we'll get into that on the reasons why it actually happened. Police was given different stories and didn't know what happened, didn't know if the victim was actually going to make it, if he made it, all that good stuff. So DeMarcus Charles was transported to the Lafayette Hospital where he underwent surgery, and y'all, he survived despite being shot in the leg and the torso. At this time, police were still trying to locate James Mouton, the other person who was involved in the altercation, who was a witness that his mother, gunned down DeMarcus, but he wasn't a suspect in that particular shooting. Now, it is said that in the state of Louisiana, you are going to be charged with the same charges if you were associated with it. If you knew that was going to happen, that altercation was happening, he left the scene, he went get his mom, and he brought his mom back to the scene. He obviously knew what his mom's plan was going to be, so I guess that's why he's on the run, because he knows that he's going to be charged for this as well, or the attempted second-degree murder. So he was not able to be located at the beginning of this lovely investigation. So, background on this case. Kathleen Mouton was charged with the attempted second-degree murder, and on August 1st, 2018, this is whenever the grand jury indicted it. On August 10th, 2018, the defense counsel filed a motion for a preliminary examination. The trial court granted the motion and ordered the hearing to be held on September 13th, 2018, literally a little over a month later. On that date, the defense counsel indicated that a discovery was received from the state, and according to the minute entry in this case, the matter was passed without another date on the defense motion. 9 months later, while Kathleen Mouton is serving in a Jefferson Parish Detention Center, on June 13, 2019, the state filed a bill of information charging Kathleen Mouton with the attempted manslaughter violation instead of the attempted second-degree murder. The matter was fixed for trial on 6 different occasions, but it was continued every single time. The first time, on June 24th, 2020, which is literally 2 years later, Kathleen Mouton requested a continuance, but the state didn't even file the continuance. On August 17th, 2022, another 2 years, y'all, Kathleen Mouton filed a motion to squash based on the untimely prosecution. The state opposed the motion, arguing that the time limit to bring the case to trial had not expired because the period of limitation was suspended by the pending motion for the preliminary examination filed by the defendant on August 10th, 2018, which, like I said previously, there was no date given after that. On August 29, 2022, the trial court granted Kathleen Mouton's motion to quash. Reason for the motion was the preliminary examination did not suspend the time limit to commence trial because it was filed before the prosecution was formally initiated. That same day, the defense counsel noted on record that he withdrew the motion for the preliminary examination. The Court of Appeal granted the state's writ application and reversed the ruling of the trial court. So they just removed that preliminary examination, okay? Now, on August 27th, State versus Mouton, the court did not address whether the motion for the preliminary examination suspended the limitation period. Instead, the court found that on August 27, 2020, the 2-year period was interrupted by the court closure in Jefferson Davis Parish due to the impact of Hurricane Laura. So they saying that due to a natural disaster and the courts were closed, that's why this trial should not, be within the limitations because of Hurricane Laura, right? But the court explained that the limitation period began running on August 27, 2020, and thus the state had 2 years from that date to commence the trial. So they didn't commence the trial within that 2-year time period. And the motion to quash that was filed on August 17, 2022 was premature and should have been denied according to the prosecution. So the court issued those 2 orders suspending all time limitations pertaining to the prosecution of criminal matters in multiple parishes including Jefferson Davis Parish. And those orders commenced on August 21st, 2020. So, again, past the 2-year deadline, which that deadline expired on October 21st, 2020. So, now we're going to get into, like, what a motion to quash. A motion to quash may be granted if the limitation period for the commencement of trial has expired. For felonies other than capital offenses, the trial must commence within 2 years of instituting the prosecution of the person that was charged. So, like the beginning of this, right? Miss Kathleen Mouton was arrested, and let me see. This was in 2018. So 2020, excuse me. So in 2019, when the state instituted prosecution on June 13th, it filed the bill of information charging Kathleen Mouton with the attempted manslaughter charge. But that trial date set after that was interrupted, and the limitation period for the trial lapsed on June 13th, 2021. So that is past the 2-year mark, right? Because June 13th, 2019, that's whenever they wanted to charge Kathleen Mouton for attempted manslaughter. And on June 13th, 2021, they still haven't proceeded with the trial in those charges. So when the motion to quash was filed on August 17th, 2022, the trial still has not started. So the motion to quash had merit, and the state bore the burden to show that the limitation period had not expired when the motion to quash was filed. But in the trial court, the state argued that the defendant's motion for preliminary examination suspended the time limit period. So this is saying, like, the motion to quash wasn't suspended, but the preliminary examination was. Okay. So under Article 580 of the Code of Criminal Procedure, this is the controlling provision for suspension of the time limits, and a very pertinent part. When a defendant files a motion to quash on other preliminary pleas, the running of the periods of limitation shall be suspended until the ruling of the court, but in no case shall the state have less than 1 year after that ruling to commence trial. So again, you got the 2-year statute of limitation, and now with this one thing, because they did the whole suspension of that preliminary, they had a year after that preliminary, right? So when the defendant requested and was granted a continuance on June 24, 2020, which was less than 1 year before the expiration of the 2-year period, on June 13, 2021, the state was permitted a year from that date to commence trial. So, like I said, June 24, 2021, that is when that deadline was up, that a trial had to be heard before that date. So this added the 60 days from the suspension of limitation period due to Hurricane Laura, brings the deadline to August 23rd, 2021. Still, like I said, August 2022, the trial's still yet to happen. The state literally dropped the fucking ball on this. The Louisiana Supreme Court granted a motion for Kathleen Mouton to quash the matter after the state failed to timely commence the trial. And the Supreme Court found that the state failed to bring the case to trial by August 23rd, 2021, which would be that timely deadline. So ultimately, this Supreme Court office and the prosecution did everything in its power to keep the case alive, but the Louisiana Supreme Court decided the case on August 23rd, 2021, which was before District Attorney Lauren took office. So, according to Jefferson Davis Parish District Attorney Lauren Heenan, she stated the following: obviously, we're not happy about the outcome, but we did everything in our power to keep the case alive. So, she took office in April of 2022, and the Third Circuit sided with the district attorney, but the Supreme Court did not. She said that the state can no longer pursue this case. So Mouton was arrested in August 2018 in connection with the shooting on South Main Street in Jennings, and she shot DeMarcus Charles several times before she fled the scene. And the matter was fixed on trial, like I said, on 6 different occasions, but was continued each time, surpassing that deadline. Kathleen Mouton did one continuance, and that was on June 24, 2020. So it still did not help anything in this instance for the prosecution. All other delays were requested by the state due to court closures or, according to the court documents, Judge Stephen Gunnell granted the motion to quash, which the state appealed to the Third Circuit, who overruled the judge's decision, citing that the delays were justified due to the closure of court due to the natural disaster of Hurricane Laura. Kathleen Mouton and her defense team later filed an appeal with the Supreme Court, and the Supreme Court disagreed with the previous rulings and said that the state had an additional 60 days to bring that case to trial, which would have been August 23, 2021, and they failed to do so. The Supreme Court of Louisiana says the time has run out to prosecute Kathleen Mouton from Jennings, Louisiana, accused of attempted manslaughter. Kathleen Mouton, who was accused of shooting a man who got in a fight with her son, James Mouton, will no longer face an attempted manslaughter charge due to a delay in the start of her trial. The case was set to go, but continued each time, once at the request of the defendant and others at the request of the state. The state's argument revolved around a motion for a preliminary examination hearing, but it was never held. So for felonies other than a capital murder, like I said, that 2-year mark is all the state has to begin prosecuting a defendant to take the case to trial. So that time can be extended, but it has to be actually extended. And in this case, it was not. So Kathleen Mouton filed that motion, and her defense attorney indicated he had received a discovery from the state and the matter was passed without date. So, like I said, the quash was filed, and it was based on the untimely prosecution. And a court of appeal letter reversed all of that and found that the parish court's closure due to Hurricane Laura interrupted the 2-year limitation period. The court ruled that the limitation period was already surpassed prior to Hurricane Laura. On May 10th, 2024, that is this year, y'all, the state Supreme Court handed down that decision, reversing the appeal court's ruling. Associate Justice Scott Critchen issued the opinion, with the Associate Justices Williams Crane and J. McCollum dissenting. The High Court found that the motion for a preliminary examination did not suspend the limitation period because Mouton did not re-urge the motion after the attempted manslaughter charge was formally filed. Justices also found that Hurricane Laura suspended but did not interrupt that limitation period. The suspension gave the state that 60 additional days, or until August 23, 2021, but they still never commenced that trial. So, Kathleen Mouton was accused of committing a violent crime, attempted manslaughter, or attempted second-degree murder of DeMarcus Charles. She will not stand trial for this offense because the majority finds the statutory trial delay was not suspended by the defendant's motion for a preliminary examination. This holding is based on 2 premises. The first premises is a motion for preliminary examination is premature if filed before the state formally initiates prosecution. And in this case, obviously, that did happen because they did not initiate prosecution. And on the second premises, a preliminary plea suspends the trial delay only if filed or re-urged after the delay begins to run. And there was no delay running. So, all of this handed down. The opinions handed down on the 10th day of May 2024 or as follows. We grant the defendant, Kathleen Mouton, the writ application in this case to decide the two issues related to the time limitation to commence a criminal trial pursuant to the LAC CRP ART 578 code. First, we address whether a motion for preliminary examination filed to the institution of prosecution trolls the time limitation to commence trial once charges are formally filed. The court holds that motion did not suspend that limitation period because the defendant did not re-urge the motion after the state filed the bill of information. Secondly, the court determined whether the limitation period was interrupted with Hurricane Laura closures. And the court held that, consistent with the orders issued addressing the impacts of Hurricane Laura, the storm suspended but did not interrupt that limitation period. Based on these conclusions, we find that in this case, the state failed to timely commence trial. Thus, we overturn the Court of Appeals conviction and reinstate the trial court's grant of the defendant's motion to quash. No other appeals can be filed in this case, y'all. Kathleen Mouton got away with second-degree attempted murder, or, if you want to go by the lesser charge that was going to be filed, second-degree manslaughter. How freaking insane is that? Her son got into an altercation with another person at a gas station or a liquor store or whatever, convenience store. But he left, went to get his mama, and she came pop, pop, pop. And she got away with it, y'all. But she has rights. Right to a speedy trial. I mean, we have all of that in place. And our justice system failed to hold that trial and prosecute her in a timely manner. I am interested to know how y'all feel about this case. Please do comment, email us, criminalbehaviorpodcast@gmail.com. You can also follow us on the Patreon. Look up Criminal Behavior Podcast, a Louisiana True Crime Podcast. And if you enjoyed the show, please rate and review us on all your lovely podcast apps. We on iHeartRadio. We would love for you to rate and review us. Please, anything helps the show. We're on Apple Podcasts, Spotify, YouTube, Amazon Music, iHeart. I mean, you name it, we on it. Wherever you listen to your podcast. And come back for next week's discussion on a lovely case. And until next time, this is your host, Sarah Studier. And don't forget to like, share, follow, or subscribe to Criminalist Behavior, a Louisiana True Crime Podcast. Thank y'all so much. And I really hope y'all enjoy y'all day. And I do know this is an episode that is shorter than normal, but this is what I got this week. And I might try to squeeze another one in at the end of the week. But if not, then I will see y'all next week, okay? Thank y'all. Y'all have a great night. Bye.